On behalf of the court, I welcome you at this public hearing, at this session for the delivering of some of the judgments. I would like to inform you that we'll deliver only 2 judgments today in the case of Kijiji Isiaga versus United Republic of Tanzania, and also Mariam Kuma versus Republic of Mali. The other judgments, namely Nguza Viking, will be delivered on Friday, and Gombert against Côte d'Ivoire. Also Anudo against Tanzania. It will be on Thursday, but you will get it will be tomorrow. Yeah, tomorrow. But we will get more details, I think, with the registrar with regard to the time, to the exact time. Dr. Ino? Okay, thank you. The court composed of Sylvain Ore, President, Ben Kyoko, Vice President, Gerani Ugeko, El Aji Gise, Rafa Ben Achou, Angelo Matuse, Ntiam Menge, Marie-Thérèse Mukamuliza, Tujilan Shizumila, Shafika Ben Saula, judges, and Robert Eno, registrar. In the matter of Kijiji Isiaga, self-represented, versus United Republic of Tanzania, represented by Mrs. Sarah Mwaipopo, Acting Deputy Attorney General and Director of Constitutional Affairs and Human Rights, Attorney General Chambers, Mr. Baraka Luvanda, Ambassador, Head of Legal Unit, Ministry of Foreign Affairs and International Cooperation, Mrs. Nkasuri Sarakikia, Assistant Director of Human Rights, Principal State Attorney, Attorney General Chambers, Mr. Elisha E. Suka, Foreign Service Officer, Legal Affairs Unit, Ministry of Foreign Affairs and International Cooperation, Mr. Mark Mulwambo, Principal State Attorney, Attorney General Chambers. After deliberation, delivers the following judgment. The parties. The applicant, Mr. Kijiji Isiaga, is a national of the United Republic of Tanzania. He is currently serving a term of 30 years imprisonment at the Ukonga Central Prison in Dar es Salaam, United Republic of Tanzania, following his conviction for the crimes of inflicting bodily harm and aggravated robbery. The respondent states the United Republic of Tanzania became a party to the African Charter on Human and People's Rights on 21st October 1986, and to the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights on 10 February 2006. Furthermore, the respondent state deposited the declaration required under Article 44(6) of the Protocol, accepting the jurisdiction of the court to receive cases from individuals and non-governmental organizations on 29 March 2010. The respondent state also became a party to the International Covenant on Civil and Political Rights on 11 June 1976. The application relates to violation allegedly arising from a procedure at the end of which the applicant was sentenced to 30 years imprisonment with 12 strokes of the cane for inflicting bodily harm and aggravated robbery. Fact of the matter, according to the file and the judgments of domestic courts, on 4th April 2004 at around 8 p.m. in the village of Kiyongera, district of Tarime, in the Mara region, 3 individuals armed with a gun and machete burst into the residence of Mrs. Robi Wambura, who was with her 2 children, Robi Chacha and Chacha Boniface. The individuals ordered Mrs. Robi and the children to lie face down, stating that they had come to claim the pension benefits paid to them from the estate of her late husband and the father of the 2 children. When the family refused to comply, 2 of the attackers injured the children using a machete, while the 3rd assailant, who was keeping guard, fired a warning shot. Mrs. Robi took the 2 assailants who had attacked the children into a bedroom and handed to them 1 million Tanzanian shilling. After counting the money under the glare of a lantern, the assailant took 2 bags full of clothes and fled. Following Mrs. Robi's and her children's distress calls, many people, including one, Mr. Yusuf Buiru, came to the rescue. Mr. Buiru subsequently stated in his testimony that he found Mrs. Robi and the children crying and calling the names of their neighbor, Mr. Biari Nyankongo, his nephew, the applicant, and another individual not identified as the attackers. The victims maintained the accusation before Mr. Anthony Michak, the commander of the local civil defense group, and later at the police station where they had been taken. The police investigation, which opened on 6 April 2004, led to the recovery of an unused bullet and a cartridge from the scene of the attack, and subsequently to the arrest of Mr. Nyan Congo. The latter allegedly admitted to having been involved in the attack, returned the stolen clothing to Mrs. Robi and the children, denounced his accomplices, and provided information on their whereabouts. Consequently, on 7 April 2004, the applicant was arrested in his village, charged with crimes of inflicting bodily harm and armed robbery contrary to Section 228, 285, and 286 of the Tanzanian Penal Code of Criminal Case number 213 of 2004 in the District Court of Tarime. The applicant was convicted and sentenced to 30 years in prison and 12 strokes of the cane. Following the applicant's appeal, the conviction and sentence was subsequently confirmed by the High Court of Tanzania, sitting in Mwanza on 5 August 2005, in criminal case number 445 of 2005, and by the Court of Appeal of Tanzania on 19 September 2012, in criminal appeal number 192 of 2010. Alleged violation. In his application, the applicants alleged that the local courts based the decision on contestable evidence, in particular the testimonies and exhibits that were improperly obtained and used. In this regard, the applicant alleged that the visual identification relied upon by the domestic courts was flawed for the following reasons. The witnesses did not say where the lamp was located and the direction of its lighting between them and the robbers. The witnesses had not mentioned the distance between them and the robbers during the crime scene. The witnesses did not define their condition after the sudden attack and how they were controlled and ability to follow the robbers' orders and instructions. If the witnesses had known well the robbers and named them immediately after the incident, why the applicant was arrested at his home after 2 days without escaping the same area. If the applicant and his co-accused were very famous to the witnesses, how they were decided to take more time for counting the money at the scene. That the Court of Appeal was required to caution itself about contradiction of facts of the prosecution evidence when PW3 had claimed that PW1 did not announce to any one of them the bringing of the stolen money at their home, but firstly was narrated that PW1 had been with money for a month. Furthermore, while PW2 claimed that they raised an alarm which brought in the neighbor to be at the scene, he said about which made him to go there in his only burst of the gun. The applicant submits that he was never in possession of the properties which were alleged to have been stolen and tendered in the trial court as exhibits. He maintains that the Court of Appeal grossly misdirected itself to apply the doctrine of recent possession against the applicant, while the exhibits alleged in the trial were said to be possessed by the co-accused. The applicant asserts that the court exclusively relied on the absence of a rival claim over the exhibits to dismiss his appeal. Prayers of the parties. In his application, the applicant praised the court to 1. Restore justice where it is overlooked and quash both the conviction and sentence imposed upon him and set him at liberty. 2. Grant reparation pursuant to Article 27(1) of the Protocol. 3. Grant any others sought that may deem fit in the circumstances of the complaints. In its response, the respondent state praised the court to declare that the application is not within the purview of its jurisdiction, and that the application does not fulfill the admissibility requirements specified under Rule 45 of the Rules on Exhaustion of Local Remedies and Rule 56 on filing an application within a reasonable time. On the merits, the respondent states further praised the court to find that 1. The government of the United Republic of Tanzania has not violated Article 3(1) and 2, Article 7(1)(c) of the Charter. 2. The Court of Appeal considered all grounds of appeal and properly evaluated the evidence before it and rightfully upheld the conviction of the applicant. The Court of Appeal properly ruled that the doctrine of recent possession and visual identification of the applicant was proper and sufficient to lend conviction. The application be dismissed for lack of merit, and last, no reparations be awarded in favor of the applicant. Jurisdiction. In accordance with Rule 39(1) of the rules, the court shall conduct a preliminary examination of its jurisdiction. In the extant application, the court notes that from the respondent states submission that the latter disputes only the court's material jurisdiction. However, the court shall certify itself that it also has personal, temporal, and territorial jurisdiction to examine the application. Objection to the material jurisdiction of the court. In the extant application, the court notes that the applicant raised issues relating to alleged violation of human rights protected by the Charter. The court further notes that the applicant's allegations essentially relate to the way in which the domestic courts of the respondent state evaluated the evidence. However, this does not preclude the court from making determination on the allegations. The respondent states objection that the instant application would require this court to sit as an appeal court and re-examine the evidence on the basis of which the applicant was convicted by the national court is thus dismissed. The court therefore finds that it has material jurisdiction to examine the application. Other aspects of jurisdiction. The court notes that other aspects of its jurisdiction have not been contested by the respondent state, and nothing in the records indicates that the court does not have jurisdiction. The court thus holds that it has personal jurisdiction, given the respondent state is a party to the protocol and deposited the declaration required in the Article 34.6 thereof, which enable the applicant to access the court in terms of Article 5.3 of the protocol, that it has temporal jurisdiction, that it has territorial jurisdiction. From the foregoing, the court finds that it has jurisdiction to consider this application. Admissibility of the application. Pursuant to Rule 39.1 of the rules, the court shall conduct a preliminary examination of the admissibility of the application in accordance with Article 56 of the Charter, Rule 40 of these rules. Conditions of admissibility that are in contention between the parties. The respondent state has raised two objections to the admissibility of the application relating to the requirements of the exhaustion of local remedy and the filing of the application within the reasonable time after the exhaustion of local remedies. Objection relating to non-exhaustion of local remedies. In the extant case, the court notes from the record that the applicant went through the required criminal trial process up to the Court of Appeal, which is the highest court in the respondent state, before bringing his application to this court. The court therefore finds that the applicant has exhausted the local remedies available in the respondent state's judicial system. Accordingly, the court dismisses the objection that the application did not exhaust local remedies. Objection relating to not filing of the application within a reasonable time. The respondent state does not dispute that the applicant is a lay, indigent, and incarcerated person without the benefit of legal education or assistance. These circumstances make it plausible that the applicant may not have been aware of the court's existence and how to access it. In view of these circumstances, the court is of the opinion that the filing of this application 2 years and 11 months after the exhaustion of local remedies is a reasonable time, and therefore dismisses the respondent state's objection in this regard. Conditions of admissibility that are not in contention between the parties. In conclusion of this part, the court finds that the instant application fulfills all the admissibility requirements specified in Article 56 of the Charter and Rule 40 of the rules, and accordingly declares the same admissible. The merits. Allegation relating to violation of the right to a fair trial. First, allegation relating to evidence relied on to identify the applicant. The court is of the opinion that the manner in which the domestic courts evaluated the facts of evidence does not disclose any manifest error or resulted in a miscarriage of justice to the applicant, and hence requires the court's deference. The court therefore dismisses the allegation of the applicant that the testimony of visual identification relied upon by the Court of Appeal was fraud. The allegation on failure to provide legal assistance. In the instant case, it is not in dispute that the applicant was not afforded free legal aid throughout his trial. Given that the applicant was convicted of serious crimes, that is, armed robbery and unlawful wounding, carrying a severe punishment of 30 years and 12 months imprisonment, respectively, there is no doubt that the interest of justice would warrant free legal aid, provided that the applicant did not have the required means to recruit his own legal counsel. In this regard, the respondent states does not contest the indigence of the applicant, nor does it argue that he was financially capable of getting a legal counsel. In these circumstances, it is evident that the applicant should have been given free legal aid. The fact that he did not request for it is irrelevant and does not shun the responsibility of the respondent state to offer free legal aid. The court therefore finds that the respondent state has violated Article 7, 1C of the Charter. Alleged violation of the right to equality before the law and equal protection of the law. The court notes that the right to equal protection of the law requires that the law, I quote, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth of or other status. The court notes that this right is recognized and guaranteed in the Constitution of the respondent states. The relevant provision, Article 12 and 13 of the Constitution, enshrine the right in similar form and content as the Charter, including by prohibiting discrimination. The right to equality before the law requires that all persons shall be equal before the courts and tribunals. In the extant application, the court observes that the Court of Appeal examined all grounds of the applicant's appeal and found that it did not have merit. In the interest of justice, the applicant was even allowed to file his notice of appeal out of the deadline specified by the domestic law, and his appeal was duly considered. In this regard, this court has not found that the applicant was treated unfairly or subjected to discriminatory treatment in the course of the domestic proceedings. The applicant has therefore not adequately substantiated that his right to equality before the law or his right to equal protection of the law was contravened, and thus the court dismisses its allegation that the respondent state has violated at Article 3, 1 and 2 of the Charter. Alleged violation of the right to non-discrimination. In the extant case, the applicant simply asserts that the Court of Appeal violated his right to freedom from discrimination. The applicant does not indicate the kind of discriminatory treatment that he was subjected to in comparison to persons who were in the same situation as he was, nor does he specify the grounds prohibited under Article 2 of the Charter on which basis he was discriminated. The mere allegation that the Court of Appeal did not properly examine the evidence supporting his conviction is not sufficient to find a violation of his right not to be discriminated. The applicant should have furnished evidence substantiating his contention. In view of the foregoing, the court finds that the applicant is not a victim of any discriminatory practice that contravenes the right to freedom from discrimination guaranteed under Article 2 of the Charter. Remedies sought. In his application, the applicant prayed the court to, among other things, quash his conviction and set him free, grant other reparations and order such other measures or remedies as it may deem fit. On the other hand, the respondent states prayed the court to deny the request for reparations and all other reliefs sought by the applicant. Article 27(1) of the protocol provides that if the court finds that there has been violation of a human or people's rights, it shall make appropriate orders to remedy the violation, including the payment of fair compensation or reparation. As regards the applicant's request that the court quash the decision of the National Court, the court reiterates its decision in the matter of Ernest Francis Mtengwi versus the Republic of Malawi, that it is not an appeal court to quash or reverse the decision of domestic courts. Therefore, it does not grant the request. Concerning the applicant's request for an order of his release, the court recalls its decision in Alex Thomas versus Tanzania, where it stated that an order for, and I quote, an order for the applicant's release from prison can be made only under very specific and or compelling circumstances. In the extant case, the applicant has not provided proof of such circumstances. Consequently, the court does not grant the prayer without prejudice to the respondent applying such measure proprio motu. With respect to other forms of reparation, Rule 63 of the Rules of Courts provide that the court shall rule on the request for reparation by the same decision establishing the violation of human and people's rights, or in the circumstances so required by a separate decision. In the extant case, the court notes that none of the parties made detailed submissions concerning the other forms of reparation. It will therefore make a ruling on this question at a later stage in the procedure after having heard the parties. Costs. In their submissions, the applicant and the respondent state did not make any statements concerning costs. The court notes that Rule 30 of the rules provides that unless otherwise decided by the court, each party shall bear its own costs. The court shall decide on the issue of costs when making a ruling on other forms of reparations. For this reason, the court, unanimously on jurisdiction, 1. Dismisses the objection to the material jurisdiction of the court. 2. Declares that it has jurisdiction. On admissibility, dismisses the objection to the admissibility of the application, declares the application admissible. On merits, holds that the respondent state has not violated Article 2 and 3(1)(2) of the Charter relating to freedom from discrimination and the right to equality and equal protection of the law, respectively. Holds that the respondent state has not violated the right to defense of the applicant in examining the evidence in accordance with Article 7(1) of the Charter. Holds that the respondent state has violated the applicant's right to a fair trial by failing to provide free legal aid contrary to Article 7(1)(c) of the Charter. Does not grant the applicant's prayer for the court to order his release from prison without prejudice to the respondents applying such measure proprio motu. Orders the respondent state to take all necessary measures to remedy the violation and inform the court within 6 months from the date of this judgment of the measures taken. Reserves its ruling on the prayers for other forms of reparation and on costs. Grants, in accordance with Rule 63 of the rules, the applicant to file written submissions on the requests for reparations within 30 days thereof, and the respondent state to reply thereto within 30 days. Signed, all the judges. Done at Arusha this 21st day of March in the year 2018 in English and French, the English text being authoritative.